All right, we are joined today by Owen Logan, who is a civil litigator at Meridian Law Group. And Owen is building or has built a rather unique practice amongst civil litigators in the city of Vancouver and possibly the country, actually, in terms of helping individuals sue immigration lawyers, consultants, basically negligence matters in immigration.
He's become a bit of
Um,
a local celebrity, I must say, actually. We were talking about you, Owen, on our we recorded a podcast that we haven't posted yet about access to justice. And we were all like, oh, Owen, that guy. He's the one that fights for people who have been exploited by unscrupulous consultants. So I remember him because I think you were working with the advocates over at the Migrant Worker Center, and so they were talking about some of the work that you had been doing in collaboration with that organization as well.
Yeah, I had done a presentation for them actually on how to kind of identify what cases fall into which bucket and then which ones, if they fall into a particular bucket, which ones to send to us and what to do
Mm.
otherwise.
Hmm.
Yeah, they do great work over there.
Yeah, they
yeah.
really do. And I think you've just filmed a documentary, haven't you?
Yeah, well, I was interviewed for a documentary, and I'm
Okay.
crossing my fingers I make it to the final cut.
Mm.
I put this up on LinkedIn before I have any control over what the end product is, but it's a guy doing a documentary on basically it's mainly focused on international students being exploited, um, but he goes into slightly other stuff as well. So he's following three people's stories about who had bad outcomes in the immigration system and tracking their kind of progress over the summer when he's hoping for good resolutions. And then he interviewed a bunch of experts, well, experts and me, I guess, on the topic.
Yeah, we have a whole host of questions. We put it out on Twitter, X, and LinkedIn. And a few of the questions, and the easiest one to start with is just maybe you could provide an overview of what you do and what sort of cases you've seen or helped in.
Yeah, so broadly speaking, we take cases in what would be called professional negligence. So that's where there's negligence committed by a professional. And those don't always have to be regulated professionals. Those can be just general professionals. So you might have a case in professional negligence, for example, against like a plumber. So we're taking the principles from that and applying it to immigration advisors, so immigration lawyers, consultants. Um, and those are the cases in negligence we take. So those typically are against people who offer their services as professionals. We do also take cases in kind of contract where there might be breach of contract or fair dealing in contract and things like that. But the majority of the work at the moment is in negligence.
And
Okay.
so what sort of cases have you taken on in terms of like maybe, one or two examples of conduct that rose to the level that litigation was pursued?
Yeah, it's a great question, that one. So the, as a very quick overview on it, you basically have to prove, in order to succeed in a case in negligence, you have to prove that the conduct of the person fell below the standard of care required for somebody in that profession. So that's really where the bulk of your analysis goes, whether a case becomes negligence or not. And so you have to view the conduct of that person versus people who have the same experience and qualifications. So an example of a case that we would have had was where a couple was going through their PR application as a common law, and they had provided all their documents to their immigration advisor, and this advisor had uploaded all their documents um to their profile, and they hit submit, but one of the documents was incorrect. So they had uploaded two police certificates for the same person instead of one police certificate for each of the individuals. And then as a result, it was the main applicant's police certificate that was wrong. And so as a result, both parties' application got rejected and they had to restart the whole process again. So that was an example of one case we took. And we didn't go to trial on it. That one settled before trial, so there's no court decision on it. But That's an example of a case where we felt it got to the level of negligence. There was another case, for example, recently we were talking to somebody and they had hired a representative to sponsor their partner from abroad to come in. And so they submitted the full application. It was being processed. And while it was being processed, the IRCC sent out a letter requesting further documentation on some particular issue. I don't know exactly what issue it was, but the advisor had missed the email completely. And so they missed the 30-day deadline to provide that documentation. And as a result, the application then got rejected because they didn't provide that documentation. They missed the email saying the application had got rejected. And so they found out about all of this about 3 or 4 months after the initial letter got sent, and so past all the appeal periods. So that's an example of a kind of case that we would say rises to the level of negligence.
Yeah. And you mentioned that that first one didn't go to trial. What is the process from, say, I know they're all probably different, but from start to finish, does it just, what are the steps? Like, do you have to do a demand letter? Do you go straight to litigation? If you do, kind of step by step, the hypothetical one going to trial and where that, when you said it's settled, where that may occur during the process.
Yeah, a great question. So the easy way to explain it is that about 95% of files settle before trial, and they'll settle at some point throughout the whole process. So as soon as there is something like negligence, that's when your claim starts, right? And so in theory, the other side could settle your claim the day after the problem happened. They could settle it on day one. And if not, you have 2 years from the time of the negligence or 2 years from the time you found out about the negligence to start your litigation. So you can initiate your claim with like the insurance company, or you can advise the person who is negligent within those 2 years. If they take no steps to resolve it in those 2 years, then you're going to have to litigate it if you want to move it along. You can litigate earlier than the 2 years. You can litigate one day after the negligence if you want. It's just that there's additional costs associated with litigation. And so if you sue somebody and you lose the case, you're going to have to pay their costs. So there's a risk involved in litigating a claim as well. So if hypothetically you spend 2 years arguing with their insurance company, the insurance company says, we're not paying you any money, we don't think you have a claim, you would then file a notice of claim at the small claims court or a notice of civil claim at the Supreme Court. It always kills me that they don't call those the same document in both of them. They call them exceptionally similar ones. So what you do is you start the notice of claim or notice of civil claim. You serve that on the defendant so that they're aware of the claim. And that kicks in a bunch of deadlines that start. So you have 21 days for them to file a response. And then you have, I believe it's 7 days after that to file a reply if something comes up in their response that you hadn't covered. Then that ordinarily, that takes longer than the 21 days they actually have, because it takes them a while to find a lawyer, hire a lawyer, that lawyer to actually investigate what happened. And so often people give extensions for that, because if you need to amend your responses later on, it just causes more delay and more costs to everybody. Then after that stage, you move on to document production. So you produce all your documents that prove your claim. They produce all the documents that prove their claims. Often there'll be document requests that go back and forth. So one of the document requests, we'll always send is the full immigration file, as well as all due diligence they had done and all internal communications regarding that client. And then we'll submit stuff like ATIPs so we can get all the documentation that was submitted to the IRCC. So we know all of that. And then if presuming the claim doesn't settle at that point, you would move on to do examinations for discovery. So that's where you get to ask the other party questions under oath, find out their version of the story, and try and poke holes in it as best you can. Usually that happens about a year before trial. And then you move on after the examination from discovery or for discovery. You just continue preparing for a trial, which you then move towards and hopefully settle slightly before the courtroom steps, so that you get the file resolved early. So settlement can happen at any point, but those are kind of the big milestones in the litigation. And a lot of the work in the middle of it is document production and getting the documents that kind of either corroborate your evidence or prove your material facts.
And what portion of your practice is focused on immigration negligence style claims as opposed to other types of negligence claims?
It's about 50-50 at the minute for me. So the other half of my practice is in insurance defense work.
Right.
And so those cases are that practice area is going away now with the changes to the personal injury laws and the Motor Vehicle Act, or the motor vehicle accidents. And so these are the only types of cases I'm taking on at the moment. So hopefully next time I talk to you, it'll be closer to 75-25 and then 100% soon after that, hopefully.
Mm. And how did this come to pass that like you started seeing this influx, that this is like an area of practice? I'm curious about how this came about.
Yeah, it was. So I came here originally from Ireland on an IEC visa, and then I got my PR in 2015. I think I got it the first year of Express Entry, when everything had moved online. And so I had, part of your discussions every week with everybody who was going through that process was how difficult it was and how the documents made no sense. And the more I spoke to people who were going through it, and I still have these conversations, everybody's confused, nobody knows what to do, and everybody's put off by the price and the expense of hiring people. And one thing I kept hearing anecdotally over the years was people running into problems for their applications, even after they had hired people, or um, just being kind of left in the dark. And there was just seems to be lots of problems that I had heard about anecdotally. And then when the changes got announced to the motor vehicle litigation, I sort of looked into it a bit deeper and found that actually there is nobody really practicing in this area. And it seemed an underserved population. And I thought that if I was able to get a few cases at the start, I could see what it was like. And those cases went relatively well. And so I've just continued on trying to build and promote my services in that area.
And are
Yeah.
you seeing mostly cases of what you see as negligence, or are you also seeing a large number of cases involving real fraud?
It's very varied is the answer. I mean, there are cases where there's just genuine mistakes happen.
Hmm.
And that happens when you're humans, right? Like we will make mistakes. And you do see a lot of cases where there are people, I don't know if they're even knowingly committing fraud. They're sometimes just making promises that realistically they can't follow through on. And I don't even know if they know themselves they can't follow through on these. So we spoke to some people recently who were recruited from abroad and offered jobs here through provincial nominee programs that didn't either the jobs didn't exist or they hadn't started any of these applications to these provincial nominee programs, but they just wanted to get the people over and to try and basically place them later on. And so in a case like that, I'm not even sure if the business owners knew what they were doing was against the rules or illegal. They just thought if we can get these people in, we'll eventually get them into jobs and the immigration stuff will follow after that. So
Hmm.
I mean, we see a lot of both is the answer. We do see things that are negligent and then things that are kind of fraudulent in a lot of ways as well.
And are the fraudulent cases also something you take on?
If if they're a registered advisor, so if they're either an immigration lawyer or an immigration consultant, it's something we would take on because those people have insurance policies behind them, and the insurance policy means someone's going to have to is going to be there to pay at the end of the day. Um, if people are able to kind of pay by the hour or pay your hourly rate, it's possible to take on those cases as well, because you're not guaranteed money at the end of it, so it's hard to take them on a contingency.
Right.
What I often advise people in those kind of fraudulent cases is to actually do something like a demand letter, to see if they'll actually pay out initially. Sometimes that works and sometimes that doesn't. And it's a really hard one to explain to clients that we can send this demand letter out to these people and we just don't know are they going to act on it or not act on it. They might take our letter and just throw it in the trash, or they might take our letter and actually refund you the money you paid them.
Yeah.
Hmm. And in terms of, sorry, two questions here. One of them is about when there is an insurer, does the insurer end up becoming like a separate party in the litigation when you're doing it? So you're suing both the representative and the insurer. So I'll start with that one, I guess.
So in the actions, what we do is you'll typically name the individual advisor and the company that they work for.
I see.
And sometimes these people can be sole proprietors, so they'll be the same party. And what happens is the insurance then steps in and acts as their lawyers on their behalf. So
I
uh,
see.
they have a duty to act on their behalf to defend them, and then a duty to indemnify them for losses as well.
I see. So they're not actually a party to the litigation. They are just they're there as an indemnifier or as a representative of the claim.
Yeah, and they give the instructions to the lawyer that's battling the claim as well.
I
So
see.
it's the insurance company's lawyer that basically fights the claim on behalf of the advisors.
I see. And then the other question is, in terms of those who are not acting, is there not, like, have you been involved at all in involving the law societies in respect of unauthorized practice of law, or that's just not something that you have entered into at this point?
I've tried is the answer, and I've not been. It's been challenging. It's not
I
been
see.
an easy road. So there is. I contacted the Law Society about a company that was offering immigration services based out of Gastown. So, like you could have gone outside the Law Society's office and thrown a stone and hit this office. And I tried to explain to them that there was no lawyers working for this company and there was no immigration consultants working for this company. So they were practicing immigration law, but without any of the legal authority to do
Credentials.
so.
Hmm.
And they basically said to me, well, we need some victims. So if you can give us a victim, we'll maybe look into it. And so I passed them on the details of somebody been, who had paid this company money and not received the services they had been offered. And they have seemed to have done nothing about it ever since. And that seems to be the problem, is that the Law Society's position, from based on my experience in it, is that the unauthorized practice of law is only going to be clamped down on if they have victims who are willing to come forward to them. Um, and that's problematic to me in a way, because that's not the way other regulators seem to combat this issue. And it seems to be the same for the College of Immigration Consultants as well. They don't seem to have a desire to clamp down on unauthorized practitioners either.
Hmm.
Do your um, clients have to be in Canada? Like if so, a lot of these mistakes obviously are going to result, well, there's two scenarios that I can see. One, where someone's negligence may result in an application being refused and the person can't come to Canada, or the second, where someone winds up having to leave Canada, including even halfway through maybe your litigation against the consultant. So how would that work both if someone's never been in Canada or if they are removed during the process?
So there's no like residency requirement to start a case in the BC Supreme Court. So the plaintiff doesn't have to be a resident or living in Canada. The kind of rule is you're meant to start the action closest to where the defendant resides or conducts business. So if a person outside of Canada had hired um, like a firm or a consultant based in downtown Vancouver, you'd have the jurisdiction then to take the action in downtown Vancouver, even if that person had never been in Canada or had never or has had been here and had to leave. So you have that jurisdiction, and especially if those services that the person received was provided through a company that's registered in BC, that would also give the court's jurisdiction here as well.
Yeah. And if they have to leave during the process, the
Uh,
matter could continue or
yeah, there's COVID has thrust the legal system into the modern world in a lot of ways with Zoom hearings. So typically the court will require the parties to be there in person for a trial, but things like examinations for discovery can be done over Zoom, and things like the document discovery process that can all be done remotely as well. So a person will very likely have to be here in person for trial, and that's because judges assess their reliability and credibility in their testimony, and they really like doing that in person. So if somebody had been here, lost status, and had to leave the country as a result, they could start a lawsuit from abroad, provided that we have the jurisdiction against the defendant, and then they would have to then come back for the trial.
Mhm. So it sounds to me like there are two major components to these cases. One is like establishing the fault, and then the second component is trying to quantify what the loss was. Am I right generally that that's sort of the two major legal the two legal projects that come into play. Is that right?
Yeah, that's correct. It's basically a two-step analysis. And step one is the fault or the liability. So in order to assess that, you have to establish that the person has a duty of care towards the other person. And so if you've signed a retainer with that person, that's going to be great evidence that that person owes you a duty of care. And so once you've established there's a duty of care, you then have to see if they've breached the standard of care. So have they fallen below the standard that's required of that person? So that's your kind of liability analysis.
Mm-hmm.
And so we'll say if you cross those thresholds, you establish the duty of care, establish that they fell below the standard of care, then what you're looking at is the second stage, which is damages. So what losses they've suffered.
But can we go back first to this standard of care? Because like I understand the duty of care, and that should be, I imagine that that's a bit more simply established if there is a retainer agreement and there is clear evidence that there's an engagement. But the standard of care, like especially when you're talking about something like uploading a police clearance, is it the right type of clearance? Like, can you just walk us through in a little bit more detail how you establish that the standard of care was not met?
Yeah, that is this is a question that's a real challenge every time you get to court. So
Mm,
it always becomes very fact specific, the standard of care.
for sure.
And the court will look at things like this that they basically don't understand, and they'll rely heavily on expert evidence to be provided on that basis. So what we would do in our cases is you would hire an expert to assess the file, right? So they'll have a look at the person's immigration file, the documentation around that, so communications, what was submitted to the IRCC, and then they'll provide opinion evidence to the court saying whether or not this person fell below the standard of care or did not fall below the standard of care.
Mm,
So there's Rule 11 in the Supreme Court Civil Rules allows parties to give opinions if they're an expert in a particular area. And there's really strict rules on preparing a report for that and serving it. And those are the only people allowed go in front of the court and give opinion evidence. Everyone else is only allowed to give fact evidence. So the process you would do is find an expert, give them the instructions, ask them the specific questions of what went wrong, and ask if, in their opinion, this fell below the standard of care for a person of that skills and qualifications.
mm,
Now, if you had a case that already had established that that action fell below the standard of care, you don't necessarily need that expert report for the second one.
mhm.
But the problem we have with all litigation is they're always going to be on different sets of facts.
Mm.
So there's going to be different facts every single time, and you're going to be safer getting an expert report every time instead of relying on the previous precedent. So if, for example, the case we were talking about where there was police certificates uploaded incorrectly, if the court had held in a previous decision that uploading, the employer letters was fell below the standard of care if you uploaded the incorrect ones, and then you tried to rely on that in the next case to say the same would apply to police certificates, you're kind of rolling the dice hoping the judge agrees with you on that. But if you get an expert report that says this would be the same and it would fall below the standard of care, then you're doing your best to cross that
Yeah,
evidentiary threshold when you get
yeah.
to court.
Best evidence. Yeah.
So one of the questions that we got was in federal court, one of the grounds for judicial review can be an argument that counsel was incompetent. Would a federal court finding, like let's suppose that the federal court in a decision found that not uploading the correct police certificate was incompetence of counsel, would that finding of incompetence in the federal court let you make the same presumption that it was negligent? Like does the test for negligence and does the test for incompetence of counsel mirror the test for negligence?
It doesn't mirror them, and the decision in the federal court isn't binding on the civil courts, but it would be very persuasive. I think you'd be battling hard if you're trying to say that the finding of incompetence of counsel in the federal court was completely incorrect and the Supreme Court should find differently.
Mm,
I think that'll be a real uphill battle for the defense lawyers on that one.
mm,
I think if I was sitting on a file and I haven't had the chance yet where there was a finding in the federal court of incompetence of counsel, I'd be very confident in my position
mhm.
going into an application like that or a trial.
Yeah, the federal court certainly doesn't come upon those decisions lightly. So, so I imagine that you would have a pretty strong argument to make in Supreme Court.
Yeah, it would be great. The court is like fiercely independent and really like battles their independence. So they don't like any decisions being binding on them at all. And so I think they'd find these things very persuasive, and especially federal court decisions that deal with immigration issues all the time.
Hmm.
The Supreme Court civil judges typically don't see immigration related issues very often.
Hmm. Hmm. It would be kind of like an expert opinion, I imagine, if that was sort of an opinion by the federal court that this was incompetence.
It would be. And I like if you had a decision like that and the defendant didn't appeal it, something like that is also very persuasive. If you can then say, well, if you really didn't agree with this decision, why didn't you appeal it?
Mm,
And I think that's another hurdle for them to have to argue in front of a judge in the Supreme Court to
mm,
say, well, I just wanted to just sit there and I didn't appeal it because there's costs, et cetera, et cetera. But in this hearing, you should totally find different.
mm. Yeah.
And on the question of damages, like um how do you determine what damages are in an immigration matter?
Yeah, this is the when you give the most lawyerly answer ever, where I say it depends.
Yeah, and I know you said you could spend an hour talking about this, but you've got a few minutes.
Yeah.
I can go very quickly on this. Talking fast has never been an issue for me. Don't worry.
Mm,
Yeah.
That the very useful thing for quantifying damages is that damages are quantified in cases of negligence all the time in front of the Supreme Court. So it really does depend on the person's individual like facts and factors in their matter, right? So if, for example, so there's heads of damages that will always apply. So there's things like past wage loss, there's future wage loss or capacity, there's special damages, general damages, there's money for loss of opportunity. So there's all these buckets that you would basically have to plead at the start of your case, and then lead evidence when you get to trial that there was losses in relation to these. So if, for example, you had a person who was lost status and they were able to stay in Canada, but they were out of work for a year, they got status back 1 year later to the day, right? That person then would very likely have a claim for lost wages during that year. So if they were earning $50,000 in a year, that would be a past wage loss of $50,000. Now you do have to take off taxes. So awards from the court are net of taxes. So it would be whatever the equivalent of that person's losses after taxes would be. And so we'll say in that year they were part of a union and there was promotions going, and this went based on seniority. So if they missed out on a promotion as a result of that, then you'd be able to claim money for that future loss of earnings for the promotion and that loss of opportunity. So if that promotion was worth an extra $10,000 and they had another 10 years left working, that might be another $100,000 in terms of future wage loss, as long as you could prove that they were likely or going to get that promotion.
What about family separation? Is there a way to quantify that?
That would come under general damages because that's what's called pain and suffering. And now the court has been slow in adapting kind of general damages for kind of pain and suffering without it being attached to a specific medical or physical condition. And so, in order to establish claims like that, you probably want to get them seen by an expert who has, like, either a psychologist or a psychiatrist that could sort of establish that there was mental health issues related to this, stuff like depression or anxiety, or low mood, or major depressive episode is often one you'll see. So, if you can establish with the evidence that somebody suffered from these kind of conditions, it would fall into general damages. And I mean, those are particularly difficult situations where there's family separation and you're missing out on milestones for your kids and everything. Like, it's the kind of thing that the court would be very sympathetic to, provided you can lead the evidence that supports a claim like that.
There's not sort of recognition that because this family now cannot be reunited, that there's just kind of an understanding that that damage would ensue.
Not really, not until we can establish some case law on that.
Mm,
If you can if we can get in front of the court and argue that and win damages on that and that head of damages on that basis, then the next time you go to court, you have the precedent to rely on.
Mm.
Yeah.
Are there some I mean, that's a good point. Are there some good cases for people to be reading in respect of quantifying damages in an immigration type scenario?
So the answer is there's no case in BC so far that's gone to trial on this
Uh,
issue. So in terms
okay,
of quantifying damages, you'd be relying on other cases of professional negligence
I see.
to look at it. And that's the way it'll be for us when we get to the first trial on this. We're going to have to say, here's the principles that apply to, like, we'll say an accountant doing professional negligence, and it should apply here. And these are the losses as well.
Right.
Um, I mean, the good news is the Supreme Court's been quantifying damages on all these heads of damages for more years than any of us have been around for. So they're very good at quantifying damages. You just have to lead the right evidence on it, and that becomes very fact specific on a case by case basis.
And that's because the cases that you have been handling so far have all settled prior to there being a trial and a decision made by the courts.
Exactly. Yeah.
Okay. Because I mean, the challenge that I think we see from clients that we're dealing with, and many of which I've referred to you, is that, a lot of them have truly lost opportunities that mean that they may never be able to become permanent residents. This is something you and I discussed over LinkedIn in a way that with the immigration system being so competitive as it is right now, when there is a serious case of negligence, or particularly when there's a case of fraud, there may be lost opportunities that mean that their opportunities to immigrate are forever foreclosed. If something like even something that is like a pretty simple mistake, you've failed to provide something, and now the score has gone so much higher that you're not going to qualify for the foreseeable future, and there's really nothing that can be done. If a judicial review application is unsuccessful, there's nothing that can be done. And I just kind of I'm trying to imagine how you would quantify those types of future costs. Like, is there anything you can tell us about how you would go about, let's say you're talking about a skilled worker who now cannot immigrate and they would be returning to Nepal? How would you go about quantifying future wage loss in that kind of a scenario?
Yeah, it's a great question. And the answer is it's really, really hard to do. So the useful thing is that the test for future earning capacity in the Supreme Court is that it's to be assessed, not calculated. So it's based on the judge's assessment and not necessarily on like multipliers or evidence. Now, those become part of what you present to the court as evidence, but the ultimate decision is assessed. So it's what the judge really believes. I did a case. We had a trial last year where the judge, the decision came out, I think, October last year. The judge just made a determination based on the evidence before her in court that the plaintiff was 80% likely to be promoted, but because of the accident he was involved in, he didn't get this promotion, and so she awarded um, money for that promotion for a few years in his future. And that was just her assessment of the facts. She came to this determination based on the evidence presented to her. And so in a situation where somebody has sort of been they're unlikely to be able to immigrate to Canada and they've lost this opportunity, you would sort of, I think what I would do is I would present the wages that they were likely to receive in Canada, and then the wages they're likely to receive in Nepal, and sort of you would look at the difference between the two. And then you take stuff like the contributions to pensions. So what pension they might receive in Nepal versus what pension you might receive in Canada. And then that's a calculation on the difference between those two. And then you'd make your pitches to the court that, well, if this person emigrated at, 30 years of age, they would likely have gotten one or two promotions before they retired. And, that promotion would have bumped them to this salary or to this. And then there's additional benefits, like extended benefits on top of that. You typically would hire somebody like an economist to prepare a report on these kind of cost of future things like cost of future care or future wage loss, because us as lawyers, we're definitely words people, not numbers people. And these economists are the other end of the spectrum, luckily, and they help us with these expert reports to court.
Mm.
Yeah, there's also the issue I see, Deanna, that well, I'll say what the issue is first in terms of like that scenario that Deanna raised where someone may not have options is I've been involved in cases where, as an expert witness of whether someone had a foreseeable chance of immigration, both where I was the only expert on both sides or where there were dueling expert opinions.
Hmm.
Neither of those cases are public, but I see, Deanna, you have one from 2017 where you and Victor Ng, another
Hmm.
immigration lawyer in Vancouver, had dueling expert opinions on what options were available to someone.
Yeah, Victor's opinion wasn't totally opposing, you know, it was sort of like, but yeah, there were opposing expert opinions for sure. But again, they weren't widely differing.
Yeah.
But yeah, yeah, there are often opposing expert opinions. I've been an expert on other cases as well in other contexts, in the family law context as well. And I have seen that in those sorts of cases, there are often opposing expert opinions saying, well, this is an option. Well, no, but they could do this instead, you know? And again, it's like, what is the likelihood that that alternate plan would actually be viable?
And I guess that'd be the
uh,
judge would have to make that point in time determination.
Yeah, exactly. So in the family
Mm.
law case that I was an expert on, it's like, you know, well, but she could apply for this or that. No, but this is not, you know, and again, it's again for a family law judge to be having to render an opinion on whether or not alternative options that could mitigate the loss are actually viable options without any determination by immigration as to whether or not those alternative options will be accepted. So I understand what you're saying, Owen, that like it's not about a calculation, it's about um,
Yeah.
because they never get to see what the final outcome is, whether that person will be granted status in some other way. They don't see that. So it's sort of like it's a bit of crystal ball gazing, you know, in terms of what do we think we're going to award without knowing what the future actually be will
Yeah, and
hold.
and a lot of that like will come down to how well you present your case and how well you cross-examine the other experts, you know?
Mm-hmm.
And so, that's where preparing for trial becomes costly and valuable because
Yeah,
you're going to go through that other expert's opinion that, if the court really finds that that expert is right, it will be very damaging to your case. So you want to
for
go
sure.
through with, every inch of that to be like, what's your basis for saying this? What's your basis for saying this? And one thing that's very effective in cross-examining experts is to say something like, well, if this piece of information applied to this case, would that change your opinion? And they'll
Mm.
say yes. And they say, well, actually, this piece of information did apply to this case. Like, is there, that would then now change your opinion, correct? And they'll say, yes,
Uh-huh.
correct. And then you say, well, the whole factual basis of your report is a bit lost. And so the court should throw it all out, et cetera, et cetera.
It was
That's
very
very
interesting. And then one of the cases where there were dueling expert reports, when I spoke with the expert on the other side, kind of over drinks, um, we both remarked that when we read each other's reports, we were thinking to ourselves, is this the same case? Because the
interesting.
facts that each side had presented were so completely different. Um, I did have a question about uh, to what extent does somebody who wants to pursue a negligence claim have to have either either performed big diligence, like if the consultant or the
Mm.
lawyer is saying, well, you should have read your application. To what extent does that come into play?
It's a great question, Steve.
Yeah, it's a really, really good question. I mean, the answer for me is that when you hire the professional, you're relying on their expertise, right? And so if the mistakes fall within their realm of expertise, then relying on their expertise is a great answer to that in court. If something that went wrong was, for example, like someone's birth date was put in incorrectly, and the applicant had reviewed their application before it got submitted and missed it, and also the professional missed it, I think that's going to be a tough one to prove who's at fault there, because they should have seen themselves what the error was. And
Mm.
I think it's just that one's a really, really tough one, probably fact specific to each case as well.
Mm.
And then
Have,
the oh,
sorry,
go ahead.
this one is just directly coming off of that question. Have you dealt with any cases where the application itself ran aground because of a finding of misrepresentation against the applicant?
We have, not in huge detail yet is the answer.
Okay.
Um, and like I'm thinking of one right now where someone was found to make a misrepresentation. They were actually had been given a 5-year ban.
Mm-hmm.
Um, but we're kind of only at the start on that one is the answer. So we
Mm-hmm.
have seen it, but it hasn't gone very far along.
So, I mean, it's just very interesting because in the professional negligence context, it sounds like you're entitled to rely on the expertise of your representative. That is definitively not the case in the immigration field, where you are 100% responsible for any representation made in your name. So, there's a conflict here in our own legal system where immigration will ban the individual. And that sort of goes to the sort of case that I'm talking about, where that might be a thing that prevents you from being able. And again, I think that this is what kind of brings it back to what Steve is saying, is that like if you may have been aware that the person was making misrepresentations on your behalf, or at least were reckless and gave them authority, sign blank forms or whatever the case may be, would that undermine your ability to make a professional liability claim against them?
I mean, I think IRCC would just say like sue the lawyer or sue the consultant, right? Like they'd
Right.
say the
Okay.
misrep, this isn't our problem.
Yes.
But you can speak to that more, Owen.
Yeah. Yeah.
Yeah.
I'm interested.
Yeah, I think you're right. The IRCC would say that.
Right.
And I think I guess the way I would answer this is that as advisors, right, you give your client all the options that are available, you provide your recommendations, and you let them choose what they want to do. And if they make a decision that's contrary to your recommendations, I would just write an email, a CYA email to say, I've received your instructions to do this. It's contrary to my advice on this option, but we'll follow your instructions and pursue this. And that way, if they want to turn around later on and say they relied on your advice, you can say, well, my advice, and always put your advice in writing, was to do path A. You choose to do path B, aware of the risks involved in that, and now we've fallen foul of one of those risks.
Yeah.
Hmm.
And to what extent um, does an applicant have to have totally clean hands to pursue the claim? So there was a case in Ontario, a disciplinary case recently involving, I believe, a paralegal who got into some sort of fee dispute and quality of representation dispute with her clients. And the paralegal then called the Immigration Refugee Board and said, my clients all lied in their refugee claims. And I can imagine that there would be some individuals who maybe knowingly spoke with their consultant or lawyer about possibly fudging or not fully representing something. There's then a unrelated huge piece of negligence that leads to a refusal, but they're worried if I come forward, this other thing is going to come to light and I'll be deported. And that the person who we're suing, their legal team may adopt that strategy of even like bringing this to light because it will come to light in the discovery and everything.
Yeah, it's a real concern. That is, and I see that as a big problem for people coming forward with these cases. They are concerned about some sort of skeleton in their closet or something that may affect their status. Um, the answer is kind of in terms of bringing a negligence case, it really does depend if the thing that they had fudged related to what the negligence was or not. That's going to have a determination on the facts of the case, whether you win it or not. But all the facts will, if the other lawyers are doing their job correctly, all the facts will come out during discovery. And so if you go to a trial, these things might become public. And so that is a real possibility, that there is going to be facts coming out that either are, like personally embarrassing or bad for your status, immigration status, and things like that. And these kind of things would be a factor in terms of settlement, right? You might want to push for settlement because you don't want these things coming out publicly. So if you go to trial and it's a judge alone trial, the decision will come out on the court website, and these facts will be public. So there is a risk of that for people, but it is also a factor in terms of wanting to settle files as well.
Hmm.
Have you seen that scenario where someone threatens to report someone to immigration if there's a lawsuit or if there's a demand letter or something like that?
Oh yeah, I've seen that a lot. Sometimes without any grounds to it. They're just sort of threatening it in terms of putting them off proceeding with the litigation.
How do you respond to them?
We just say, do it, go for it. You know, if they don't have any control over the CBSA actually following through on these things, and you're just hoping that if CBSA investigate it, that they're not going to actually deport the person. But I think in terms of litigation, I may be a little hardened in terms of responding to threats. I just always tell people, well, if that's what you're going to do, go for it. Like, don't let me hold you back.
Am I wrong in thinking that a judge would be really pissed with a side that is threatening like to help with deportation, or you trying to employ that as a strategy in a civil litigation suit?
I think so, yeah, because that would be, tantamount to like like threatening a witness or witness tampering, right? So they're going to see these threats, especially if somebody's done it in writing. And when you get to a trial or get in front of a judge, they're assessing the reliability and credibility of all the witnesses. And so, if you're somebody going around issuing threats and trying to get people deported, your credibility in front of that judge is going to be diminished. And so if your case depends on the judge believing your version of events and they see your character that they don't like through this lens, it's probably going to negatively affect their desire to kind of find in your favor.
Yeah.
For what it's worth, too, I have found that in making applications for compassionate relief, I have found more openness to granting that relief when the person has pursued legal action against the consultant or the lawyer, whoever it is, because it shows that it's more than just lip service to like I was exploited, when they're actually prepared to take that matter before
Yeah.
a judge, or they've reported it to the college, or the law society or something like that, because it it shows that they're not just making that complaint for the purposes of supporting an immigration claim.
Mm-hmm.
So
Well, I think with incompetence of counsel, there's also a whole practice notice that almost one of the expectations before you make the claim is that you have to provide evidence as to whether a complaint had been filed.
yeah, so I know some people are really worried about the specter of a complaint to CBSA, but somebody who is threatening, it's almost all the more reason to actually carry out the legal process to try and, like start your own
Mhm.
defense, because somebody who makes the threat is probably more likely to do it than somebody who's just, trying to be cooperative.
Yeah. Suing consultants or suing lawyers, is there a difference?
Well, they have different insurers. So you are dealing with different entities on the other side. And the standard of care that you're looking at is it's a subjective standard, right? So it's based on a person's qualifications, experience, and profession. So there will be a time, hopefully, there's case law saying that there is different standards of care for both of them. Where they differ dramatically is going to depend on the facts of each case. So really big picture, there is no difference. It's both negligence by a professional. It's going to come down to like into the weeds really and the nitty gritty of the cases about what the standard of care is and is not.
Do you think it's likely that they'll hold lawyers to a higher standard of care? That it'll be easier to sue lawyers than consultants?
I wonder. I mean it's complete speculation, but I think probably because I think the court likes to hold lawyers to a very high standard generally. And so
Yeah.
I think it's quite likely that if we're in front of a judge and the judge is saying, well, would another lawyer have made this mistake? No, they're probably going to be a little harsher on us, I think, than other professions.
And what about the discipline component? Are you involved at all in the discipline component by the college versus the law society to see which body provides more uptake when there is a complaint in process?
I always tell anybody to go ahead and make the complaints to the appropriate regulator. In my experience, the Law Society is a lot more responsive to these complaints. They'll generally follow up quicker and seem to take them more seriously.
Mm.
With the college, it seems to be lost into a kind of a black hole. It's often months before you get a response, if at all. And sometimes the responses are fairly inadequate. I mean, we helped someone make a complaint recently, and their response from the college was, well, the consultant told us that they did nothing wrong, so case closed, like we're not moving forward with this, which which I thought was a pretty poor outcome because that, you know, if you're just going to believe the other party, you're not really an independent regulator, you're sort of more an advocacy group for the profession then.
Right.
Um, and I see like the college is you know, it's a new iteration of this regulator, but there seems to be a massive backlog in terms of their disciplinary actions and the cases coming out. I think I'd mentioned earlier that like, you know, the most recent disciplinary decision from the college was from February of this year and related to complaints from 2018.
Oh my
Um,
goodness.
and the second most recent decision also related to cases from complaints from 2018. So it's, you know, it seems to be very backlogged in terms of taking action against these people. Um, and funnily enough, that the most recent decision, if you read it, relates to a consultant that was dealing with a company called UIS. And that was the same company that I complained to the Law Society about for their unlicensed practice in Gastown. And so even the college doesn't think that this company is performing immigration services correctly, but nobody seems to be willing to take any action against them.
Mm. Wow. And I don't think that that can be said about the Law Society. I think we're getting discipline digests on the regular about people who have either unauthorized practiced or even very minor um, violations of the code. And we are only exposed to those in BC, but I think the same can be said for practices all across the country.
Yeah, and one thing the Law Society does is they'll take injunctions against people who are breaking their rules.
Mhm.
And they'll go in front of the court and make the case that this injunction needs to be placed against this person because they're doing the unlicensed practice of law. And I think injunctions is a really effective tool in terms of shutting this stuff down.
Suspensions, all sorts of different actions against lawyers for, yeah.
Hmm.
Hmm.
Um,
So if this will probably be my last question, just looking at the time, like if someone wants to contact you, well, I guess the obvious question is how do they contact you, but also what type of like initial questions or documents would you normally want to see? Like if someone's going to contact you instead of like a one sentence email, what sort of things can they proactively like provide to make the process of possibly getting compensation um, for someone's negligence easier?
Yeah. I guess the first thing I'll say is I have my website listed just here, I guess, for anyone
Yep.
who wants to read up on the types of information that's useful for us. Um, I have a little referral sheet that I like to send out to people who want to send cases to us, and it gets a lot of the basic information in. So what's really important for us is timelines. So dates that people entered Canada first, you know, what type of visa they were on or work permit, you know, dates they were working, dates they were not working. The one of the things we have to do first off when we get a referral is run a conflict check to make sure that people involved in this case aren't already clients of the firm. So what we like to do is get the names first, run the conflict check, and then get the referral sheet with the information. One thing that I find helpful getting referrals from people is getting a copy of their resume because that tells you, kind of gives you their life story already, tells you their education, the jobs they were in, things like that. And often people have that ready to go, so they don't have to put any work in getting it ready for you. Um, and then if they have already requested their immigration file from either the consultant or the lawyer, if they have a copy of that ready, that's always helpful. And following the mistake, if they've done something like applied for a vulnerable person work permit or made a JR, like copies of those documents are really helpful as well, because that also tells us the story of what went in. Quite often when we get cases from the Migrant Worker Center, they'll give us copies of the affidavits that were submitted for the vulnerable person work permits. And those are brilliant because it goes through all the evidence that they're looking to rely on, and it really tells the story to us as well.
Yeah. If they've secretly recorded a call with their consultant or lawyer, is that admissible?
I'm pretty sure in BC it's just a one-party consent for
Yeah.
recording phone calls, and I'm pretty sure that would be admissible in court. But we haven't come across that yet where we've had an issue submitting something like that.
Mm. I think I have my final question, which leads off from what you've said here, which is I imagine that there are many situations in which there are immigration proceedings that are ongoing simultaneous to any civil action against the representative. If those are resolved favorably, how does that impact on the quantification of costs?
Do you mean like the costs that the person's incurred? The person who person looking to immigrate, I guess.
Yes, exactly.
Yeah, I mean, if there's the immigration process is resolved favorably for them, that sort of bookends the person's damages, right? So
Right,
you're out of status like that person for a year, and then you're back in. So you have your 1 year of where there was damages, and then it's whatever flows forward from that. So one of the things I guess I didn't mention in terms of the heads of damages earlier was special damages. So you can get money for damages that like costs you would not have incurred had it not been for the negligence.
right,
So, for example, if you had to pay somebody to JR this decision or hire a whole new advisor to start a new process and get those are examples of costs you can recover.
right.
So, if the two processes are running simultaneously, it's actually can be quite helpful for the civil case if it's been resolved favorably. It's one evidence that they would have likely succeeded in immigrating to Canada anyway, that the authorities were, interested in somebody with this person's qualifications and skills and profile. And then second of all, it bookends the damages. So you can say, well, these all finished at this point. Here's the total cost they incurred as a result. Here's their total losses, and actually makes it a little easier for us to present to the court their actual losses in this.
So you might actually be able to recover the actual costs of the federal court litigation.
Yeah, we haven't had a case yet go to court where we've recovered them, but I'd be pretty confident that we would be able to. The kind of test that the Supreme Court looks at is what's called the but-for test. So would they have incurred this expense but for the negligence?
Mm-hmm.
Um, so you kind of just have to go through that analysis on each individual cost and people's special damages.
Mm-hmm. Interesting. Okay.
Yeah.
Well, it's something good to keep in mind to see whether or not there are situations in which those two things could be run. Because I think sometimes the cost of federal court litigation is prohibitive, but if these things could run simultaneously. Because you mentioned that sometimes you do run these files on a contingency basis. So if there's this way of potentially recovering those costs by doing these two things in tandem, that might be a way of running it, of working it for people to to sort of finance the federal court litigation if both can succeed.
Yeah, exactly. I mean, we take these cases predominantly on contingencies, so that means that we're kind of financing the litigation, and that's certainly a conversation we could have with people as well about it. I'm not sure there's going to be many immigration lawyers who are happy to defer payment for their services on the federal courts, but it's an example of the kind of costs that clients might be able to incur, and provided there's a strong enough liability argument on those cases, something you could recover later on.
Mm-hmm. Okay, I do have one final question. If a case went all the way from start to finish to a hearing, what is the like ballpark range of timelines if there weren't you know, um, sort of bizarre attempts to frustrate the the process?
I feel like
How
bizarre
long is a
attempts
piece
to,
of string? Yeah.
yeah, well, bizarre attempts to frustrate the process is part and parcel of civil litigation because the defendants never want the case to go to trial because, if they don't have a strong case, it's a bad outcome for them. So they're going to try and push it back. I would say your typical timeline is probably 3 to 5 years, like three on the fast side, five on the longer end, from the notice of civil claim to the trial. So if you wait 2 years to file your notice of civil claim, then you're talking about 5 to 7 years from the time of the negligence for these kind of cases.
Is that the
Wow.
Um,
same in the Civil Resolution Tribunal?
the Civil Resolution Tribunal is much quicker, they say anyway, than the Supreme Court. But I have a case that we submitted like last September in the CRT, and they still haven't assigned a representative or given us the opportunity to submit evidence. So, and that kicks off a process that lasts like 6 months. So they build themselves as very quick at the CRT, but they seem to be actually quite slow in my experience.
Wow. Wow.
It's
Wow.
a
Okay.
happy note to end on, right?
Yeah, I know. Well,
Yeah.
I know it's something that people always ask me in terms of federal court litigation, but I think it's good for people to have like a basic sense of what they're looking at.
Yeah. Well, and I also think it's very good to have you on the scene because certainly, well, up until you came on the scene, when people would contact and I mean, I get like a fair amount of emails because of my social media presence about like, hey, I think there was a negligent person. Who do I refer this? And I would think, who do I refer it? I don't know anyone who actually like specializes in this. And
Yeah.
to now have someone on the scene, um, and I don't know if there are counterparts in other Canadian provinces. If there are, certainly, do let me know. But and it's really good because there's a lot of refusals going on due to representation issues.
Yeah, and there's a lot of complexity, and like it is sure it's analogous to an accountant and a doctor, but the considerations in the immigration context are pretty unique, and trying to like, learn that entire field of practice, it's quite a lot, and having that sort of shorthand and being exposed to a large volume of cases is a real advantage. You know, being able to see what's out there, and having some of that background knowledge and having been through it yourself, I think too, is just it's a real advantage.
Yeah.
Yeah, it is. Like having gone through it, just understanding what stuff like express entry is or a COPR, for example,
Yeah,
makes it
exactly.
so much easier.
Yeah,
Being able to
knowing the
talk the
language
talk.
of
Yeah.
the client, if they, if someone comes to you for a negligence claim regarding an express entry application and the lawyer is saying, what's express entry? It's going to be a very different for an individual than, oh yeah, I know what express entry is and I went
Yeah.
through it or I've represent, I like speaking the language is
Yeah, I
so
know what
key.
an LMIA is, but I mean, again, the overall cautionary note is people need to be extremely diligent in practice. It's so easy to make a mistake right now, and the expense, like the cost, like the personal cost of those mistakes can be catastrophic for people. But also that people need to be very, very aware when they're making any application. Like you cannot just be, I mean, not aside from the personal negligence issue, you can't just rely on an expert in order to make representations. You need to read all applications and make sure you're aware what they say, because some of these mistakes can't be undone from an immigration standpoint anymore.
Mhm.
So yeah, people need to be real cautious, and all of this, like, I mean, we're hearing all these things about sale of LMIAs and all of this issue. So there's clearly with this very competitive market, there's a lot of fraud going on right now.
Yeah, and a lot of money to be made by bad actors in it as well.
Yeah, that's right. And that's what creates this market for exploitation that is definitely, yeah.
Or
Um,
the converse, where people are doing something very cheap because, say, business is slow, but because they're doing it cheap, they're not putting their full effort into it.
yeah.
And then they're cutting corners, and boom, there's a bounced application.
Yeah. Well, the system sort of presents itself as something that you can do on your own, but you know, the the number of things that can cause something to go wrong, and the grave, grave consequences of pretty minor mistakes can't be understated.
Oh my God. Yeah. Like I mean, I think we could have a whole podcast dedicated to all sorts of examples of like things that you'd think should be this way,
Yeah. I
but
think that's
aren't.
kind of what our podcast is all about, right?
I know the example I always give with it is when people are trying to do their own one, I think there's a question on the express entry that says, do you have a valid job offer? And
Right?
just take
Like,
that in its basic language. People would say, do you have, would understand that to be, do you have a job? But
Yes.
that question
Yeah.
really means, do you have an LMIA?
Yeah,
You
or a
know?
PNP nomination, and it's kind of like there's so many things that again cannot be read in their plain common sense way.
oh, the one where you get a please upload a fee receipt and then you go and upload the fee receipt. And we have a judicial review for someone right now on a reconsideration where they did what the letter said. They upload it, but they didn't know that you're then supposed to transmit it.
I have
And
two of
when you go to
those.
transmit it, the fee payment page pops back up. So it's very counterintuitive that clicking next doesn't lead to another being paid.
Yeah.
And it's all these things like, your lawyer or consultant would be expected to know how that works.
Yeah. I have
Um,
two of those JRs in the works right now, Steve. One of them got settled right at the very start before I even perfected leave. The other one they opposed. So again, it's like I don't understand what's up.
yeah,
And so, again, like the navigability issues around the use of the portal. And so while I'm very, very supportive of all of the work you're doing, Owen, around professional negligence, sometimes, like I think that's why lawyers right now are not sleeping well, because the line between like a simple human error and negligence is very thin right now.
yeah. But there's like going to what Owen said about how when you hire a representative, in terms of doing your own diligence, you should be expected that your representative would know how things work. I think that's a classic example of like no amount of due diligence beyond going into forums and then relying on like internet random people on threads would fully explain the whole upload, transmit, and all sorts of other
Yeah.
similar little nuances that only a consultant or lawyer would necessarily know. And then even there, you have to hope that they aren't, rushing through a high volume practice. Like there's all sorts of pitfalls
Yeah.
Yeah.
Yeah. But
that
again,
Owen would
how
call
you
bread and
run.
butter.
Yeah. Yeah, exactly. Yeah, but with guides changing all the time, like, yes, you need to sign the form. No, you don't need to sign the form. Yes, it's like, I mean, all these changes all the time. It's trying to run a non-negligent practice is incredibly difficult right now.
Yeah.
Yeah.
No, this was good. This was
Yeah, very much.
I think we hit everyone's questions. I know the episode had a fair amount of interest and I'm sure it'll be well received.
Yeah. Thank you so much, On, for joining us.
Oh, it's my pleasure. My pleasure.
Yeah.
Anytime.
And I'm sure we will do our best to get you up to 100% in no time.
That's my biggest fear that the floodgates are going to open now.
Yeah, yeah.